5 seconds to go. Start. Learned counsel, appearing on behalf of the appellants, submitted that while interpreting Regulation 60, the High Court has added a provision by stating that when the employee disputes his liability after receipt of the so cause notice, it is incumbent upon the disciplinary authority to conduct a detailed inquiry as provided for major punishment. It is his contention that in case of negligence in discharge of duties or loss occurred to the corporation by not following the directions issued by the corporation for taking precautions, there is no question of holding full-fledged departmental inquiry before imposing minor penalty as provided in Regulation 54. As against this, Respondent number 2 Joint Secretary Food Corporation of India Executive Staff Union, who appeared in person, submitted that under the guise of imposing minor penalties, the management of appellant is dispensing with holding of regular departmental inquiry in cases where charges cannot be proved. He further pointed out that there is large scale misuse of powers under the said regulation and therefore the interpretation given by the High Court to the said regulation does not call for any interference. In our view, on the basis of the allegation that Food Corporation of India is misusing its power of imposing minor penalties, the regulation cannot be interpreted contrary to its language. Regulation 61B mandates the disciplinary authority to form its opinion whether it is necessary to hold inquiry in a particular case or not. But that would not mean that in all cases where employee disputes his liability, a full-fledged inquiry should be held. Otherwise, the entire purpose of incorporating summary procedure for imposing minor penalties would be frustrated. If the discretion given under Regulation 61B is misused or is exercised in arbitrary manner, it is open to the employee to challenge the same before the appropriate forum. It is for the disciplinary authority to decide whether regular departmental inquiry as contemplated under Regulation 58 for imposing major penalty should be followed or not. This discretion cannot be curtailed by interpretation which is contrary to the language used. Further, Regulation 62 itself provides that in case if it is proposed to withhold increments of pay and such withholding of increments is likely to affect adversely the amount of retirement benefits payable to employee, and in such other cases as mentioned therein, the disciplinary authority shall hold inquiry in the manner laid down in Regulation 58 before making any order imposing any such penalty. Hence, it is apparent that High Court erroneously interpreted the regulation by holding that once the employee denies the charge, it is incumbent upon the authority to conduct inquiry contemplated for imposing major penalty. As per the regulation, holding of regular departmental inquiry is a discretionary power of the disciplinary authority which is to be exercised by considering the facts of each case, and if it is misused or used arbitrarily, it would be subject to judicial review. Stop.